1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်821ဦးပိုထောင် plaintiff versus People's Bank number 19 defendant ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular Suit before ဦးကျော်ဆန်းဦး Judge ဦးပိုထောင် Plaintiff versus People's Bank number 19 Defendant Code of Civil Procedure Order 33 Rule 6 Application to Dispauper Order 33 Rule 2(1) Obtaining leave to sue as pauper under duty to show that all the property consists of the items set out and value in the schedule to the petition, fraudulent suppression in the disclosure of assets, dismissal of the petition. Hell, one of the conditions required under Order 33, Rule 2(1) of the Code in order to obtain leave to sue as pauper is that the plaintiff is a pauper and that all the property of the plaintiff consists of the items set out and value in the schedule to the petition. In the matter of the disclosure of assets, any fraudulent suppression must result in the dismissal of the petition. Dhaka Prasad and another versus Srinivasa Surika and another AIR 1930 Patna 368 Chelame versus Muthu Lakshmi MA ILR 1945 Madras 628 Maharaj Bali and another versus MT Tirat and others AIR 1952 Allahabad 608 refer to Ukokoji for the plaintiff, Ulajo for the respondent, Ujosan U Judge. This application date 1st March 1966 under Order 33, Rule 6 of the Code of Civil Procedure by the defendant bank, being People's Bank number 19, is to dispauper the plaintiff on the ground that he did not correctly and in good faith give his list of properties and the valuations in his schedule when he applied to the court on 13 March 1962 for leave to find the suit in formal pauperis under Order 33, Rule 2 of the Code. In the schedule, he showed an old one-storied timber building with zinc sheet roofing and bamboo mat walling, without its side being numbered 35, Nijota Street, Chaomiao, as his value at Jet 800, amongst other movable properties valued at Jet 100, in an inquiry into pauperism before the Collector of Rangoon in Revenue Proceedings numbered Shoma 13 to 7 of 1961 to 1962 at the instance of the Attorney General. He, however, deposed that the house in which he lived, being numbered 39, Nijota Street, Chaomiao, belonged to him, though the site is state land. This contradicts his statement in the schedule of properties filed with the application for leave to sue in formal pauperis U Ranjao, an officer of the defendant bank, in his affidavit affirmed that the bank did not oppose the application as it believed that the plaintiff had stated in his schedule, and the court accordingly granted the leave applied for, but in the course of the hearing of the suit, the plaintiff deposed that he is now living on the rents he received by letting out his house numbered 39, Nijoda Street, Chaomiao. He said he was receiving over Jet 100 per month as house rent up to date. The application for leave to sue in former pauperis was made on 13 March 1962, and his deposition in the suit was recorded on 31st March 1964. In his deposition, he gave his address as 35 Nijoda Street, Chaomiao. His application entered Order 33, Rule 2 of the Code, and his deposition showed that he owns two houses, viz. Numbered 35 and 39, Nijoda Street, Chaomiao. As mentioned above, he never disclosed house numbered 39 in his schedule. In his counter affidavit, the plaintiff swore that the figure 35 in the schedule was a typist mistake and it should be 39. He craved leave of the court to amend it, but the bank opposed the application. He insisted that house numbered 39 and not numbered 35 belongs to him and it is now worth about Jet 6,000. According to him, the latter belongs to his son, with whom he is now living. The bank replied that the defendant pleaded that it was a typist mistake was an afterthought and that it is unbelievable that the house value at Jet 800 in the schedule would fetch over Jet 100 per month as rent. What it wanted to say was that if the house numbered 39 fetches over Jet 100 per month as rent, it must surely be worth more than Jet 800. The point for determination is whether, even assuming that house numbered 39 belongs to him and that he is now living with his son in house numbered 35, his suppression of the monthly income of over Jet 100 per month is a ground for dispaupering him. One of the conditions required under Order 33, Rule 2, 1 of the Code in order to obtain leave to sue as a pauper is that the plaintiff is a pauper and that all the property of the plaintiff consists of the items set out and value in the schedule to the petition. In the bench decision of the Patna High Court in Dhaka Prasad and another versus Srinivasa Surika and another one, Courtney Tarrell, Chief Judge, said it is most important that all applications for leave to sue or prefer a peace in former pauperis should set forth with the utmost good faith, as in the disclosure of assets in insolvency proceedings, the whole of the assets of the applicant. It is the practice that notice of the application is sent to the government pleader in order that an investigation may be made by government officials into the true or otherwise of the applicant's statements of facts. and therefore, it is incumbent upon the applicant to state with the utmost good faith all the necessary materials for such an investigation. If he merely states that he is a poverty-stricken individual with no assets but a few valueless articles and concede the fact that he has interest in properties of however little ultimate value, it is impossible for the inquiry to be conducted with any efficiency. In that case, the applicant did not set forth the value of his share of the equity of redemption of the mortgage in suit, and the court rejected the application for leave to appeal in formal papyrus with cause in Chelame versus Mutulakshmi M.A. 2, Leash Chief Judge said, Enter Order 33, Rule 2, it is the bounden duty of the petitioner to make a full and accurate verified statement of his or her properties. Quoting a previous decision of the court, it was further held that the utmost good faith is required of the petitioner in the matter of the disclosure of his assets, and any intentional departure from good faith, whatever the motive may be, must result in the dismissal of the petition. Lastly, in Maharaj Bali and another versus M.T. Tirat and others 3, where there was fraudulent separation of assets in that the applicant omitted to include in the schedule a decree in his favor for cause for rupee 250. The bench of the Allahabad High Court, composed of Ghulam Hassan and Modem judges, relying upon Dhaka Prasad and another versus Srinivasa Surika and another 4, held that Order 33, Rule 2 of the Code is mandatory and refused to interfere with the order of the lower court, dismissing the application for leave to sue as a pauper on the ground that the applicants were guilty of fraudulent separation of assets, which was a finding of fact. The bench held that the finding was correct. It was further held the fact that even if the suppressed assets were disclosed, it would not affect the question of pauperism. Is not relevant at all. In view of these authorities, I do not think I should allow the plaintiff application date 7 April 1966 for leave to amend his schedule. It is now 6 years that he has slept over the matter, and he would not have applied if no application was made by the bank to dispauper him. It is hard to say that he applied for leave to sue as a pauper in good faith. The said application is therefore rejected. According to his own evidence in the suit, the plaintiff was at one time at least a wealthy man, for he could borrow nearly jet 60,000 from the bank on various days within the space of a few months in 1957, and on one occasion in 1958 by pledging his diamonds, which he said were inherited by him from his mother-in-law. He stated that he lost his fortune because he was a victim of dacoity and theft, and he also gambled away his money at horse racing. He said he had never hit the jackpot, though he bet Jet 5,000 to Jet 6,000 at each meeting. For all the reasons given above, the application of the bank to dispauper the plaintiff is along with cause. Instead of dismissing the suit forthwith, I feel that it will be just and fair to allow the plaintiff to deposit the required court fee in full within a reasonable time. I accordingly grant 3-week time from today for payment of the court fee before the land registrar, original site, filing which the suit shall stand dismissed with cause on contested scale. The plaintiff shall pay 3 gold mohurs as advocate fee for the matters in hand.